I would say the number 10 on our list, which was where we intended to stop.
And I was going to ask about that. We spent this whole time really talking about all the documents that you can put together and the planning you can do to avoid, negative outcomes. But even with these documents in place, what are ways that someone who maybe feels like, for lack of better words, feels like they're getting screwed over, what are some things that they can do to challenge some of these predetermined outcomes?
I call them unhappy beneficiaries, not because like they're not happy in general, but they're dissatisfied with, their inheritance. Well, if it's, I assume there's estate planning documents. There's like a will, there's a trust. Take for example, there's no trust, it's just a will. There really is only a couple ways they could do that. I would say they can attack it from an angle of lack of capacity. They didn't know what they were doing. They didn't understand the nature of their assets, who was going to get what. They just didn't know. In that context, that's a legal determination, not a medical one. Doctors don't like hearing that. It's actually not a medical determination. It's you have the legal capacity. And when you have dementia and you have Alzheimer's, you have clear days, you have bad days, cloudy days, clear days, alternating, some worse than others. All that matters is that you're clear in the day and the time that you sign those documents. That's why you're thinking, oh, well, that's so easy to do, but not when someone's making a challenge and they're bringing the medical records and they're showing that you were on medication and you were, the week ago you didn't know what your name was. Like, those are bad facts. And so that's an invitation for somebody to argue you don't have capacity. So that's one angle, is you lack capacity. You should definitely be planning before that happens. Second way is you say, like, remember we talked about good, bad, and medium child. Someone really was controlling you, so telling you to do this, and you did it out of fear, or you did it out of misplaced trust. You were compelled to do it. You were under duress. So challenging it under that angle, that argument, is like kind of like the
Undue influence, right?
The ketchup in the hot dog. It's like usually you see both of them. You don't usually just see one of them. You see both of them all the time. The third way is to just, and this is, believe it or not, this happens all the time. The third way is to challenge them on the basis of they were not validly executed. They were not validly executed. There's all strict rules on how to do it. These online solutions, they don't do it for you. They disclaim. You sign away those liability issues. And so a lot of times you have this person who they think they have a good document for 50 years, and then they pass away not realizing, never really knowing just how vulnerable they were. And so a deposition can, I think, easily uncover the flaws in the execution. In COVID, you asked me about this earlier, off record, how we're doing it, how are we signing, how are we complying with the law? And we are doing it. We're doing it creatively. Also, I should mention, in Florida, I'm sure you're aware of this, Chad, but in July, just a couple months ago, it's October already. It's crazy.
I know, crazy.
It's been a long March. In July 1st, electronic execution of wills and trusts became acceptable. And it's not like a DocuSign. No, it's not like you can just do this Zoom call and we can just take a doc and just sign it and you saw me do it. And now it's actually quite challenging. We offer that service, except for wills. And the reason why we don't accept wills to do wills is because there's something called a qualified custodian that has to store them for like 100 years, and it's just not practical. It's easier to just get in the car and go see someone and do it. So e-signing is becoming a reality. I'm sure it's going to be litigated because there's a lot of holes in it, but challenging it, like I said, lack of capacity, undue influence, a flaw in execution, and of course the e-signing routine. You're setting yourself up if you wait, or you have bad facts and you have a beneficiary who's dissatisfied there is an attorney who will take the case. If there's money in there, they will take the case, and they will make the argument, and they'll probably settle. So that's 10. So yeah, we strengthen documents. We try to help prevent that. And that's something that we uncover pretty quickly.
Haimo, Haimo.